Yes, yes, we're ready. You can start.
Thank you very much, Director of Ceremonies, and good afternoon, countrymen and women, and the youth of our country. This afternoon, as government, we wish to pronounce ourselves on one or two issues. We believe that at a time like this one, we need to move with the rest of the nation in understanding what is happening around us, particularly to do with the national question relating to proposed constitutional amendments via National Assembly Constitutional Amendment Bill number 7 of 2025. As the nation will recall, yesterday the courts dismissed a case that was prepared before it or commenced by the opposition through Honorable Mundubile and the Celestine Mukandira, in which they sought that the court should effectuate contempt proceedings or commence contempt proceedings against Madam Speaker for the National Assembly of Zambia, the entire presiding officers bench of Parliament, and all members of Parliament, and all staff and workers of Parliament for continuing to perform or proceeding with processes relating to Bill number 7. Firstly, and manifestly, it was extremely concerning that the opposition sought to have the whole House and its leadership appear before the courts of law for contempt proceedings. But then the substantive issue for us as government is that we are now deeply concerned with a seeming tendency by the opposition and some of the members of public, particularly those in the Oasis Forum's tendency to abuse the courts of law in their attempt to overthrow Bill number 7 out of Parliament. We want and wish the nation to know that from the ruling of yesterday, which dismissed that particular case, where we stand, there is no legal impediment for the smooth progression of Bill number 7. In that same case, the contempt case, which was Mundubile and Celestine Mukandira versus the Speaker and many others for contempt, government also note with concern the tendency by the opposition to abuse the presidency and in this case, the President of the Republic of Zambia, by seeking to drag him and join him to be part of those proceedings for which them, as lawyers, are expected to have known that the Constitution of the Republic of Zambia protects the presidency and the president from commencement of legal proceedings in terms of Article 98 of our Constitution. It did not need the courts to begin to lecture them for them to know that what they were doing was frivolous, it was fallacious, and patently malicious to drag the head of state in legal proceedings for which they know there are legal provisions that exclude and would in any event extricate the head of state from being joined in such proceedings. We have now come to a firm understanding that the opposition and those they share views with now seem to be strongly intent to attempt and purport to oust the exclusive cognizance legislative authority of Parliament or National Assembly as contained under Article 76, which gives exclusively the mandate and right to the National Assembly to make or amend laws. They are trying to use the courts of law as a platform even to amend the existing Constitution of the Republic of Zambia. We want the nation to know that the much talked about Bill 7 national debate should now begin to de-escalate, because all the matters that have been brought before the courts of law have been dismissed for want of legal substance, that they are destitute of merits at law, and therefore have not been given that for which the petitioners initially were asking. And I want to take this opportunity today to remind the nation that in a bid by the opposition and their, like-minded organization, not like-minded politically, but like-minded against Bill number 7, they have put up a number of cases before the courts of law, for which the courts of law have guided and pronounced themselves, so that the nation now should move on from this debate and begin to talk about other issues that matter. On the 27th of June, 2025, the courts of law, in the matter of Muniye Zulu and Celestine Mukandia versus the Attorney General, pronounced itself on the question of requirement by government to ensure that in a constitutional amendment process such as the one before Parliament, there was need for wider consultation and or participation by the citizens. That pronouncement, in our view, was the first at law we have in the country relating to a legal requirement for wider consultations outside the expressly provided for requirement in terms of Article 79(6) to do with when you are amending the Bill of Rights via a referendum. We want the nation to understand that the pronouncement which was made by the courts of law in that case of Muniya Zulu and another versus the Attorney General, in our view, had a guiding effect of how constitutional amendments such as through Bill 7 should be done. And the court were explicit in pointing out that such requirement emanate out of practice that is already precedented in this country in terms of previous constitutional amendments. That pronouncement has the effect at law in terms of guiding how a constitutional amendment process should be performed, that there must be wider consultation in line with practice, not law. But the pronouncement itself now carries a tendency of law by being instructive in terms of guiding. We want the nation to know that notwithstanding such pronouncements, it came after Bill number 7 was already before Parliament, and therefore our laws do not apply retrospectively. And what the court then sought to guide was something which was already being performed by Bill number 7 being deferred to allow for more consultations that included the setting up of a technical committee and also the holding of a dialogue meeting with 34 civil society organizations and faith-based groups and others with the President at State House, and the other subsequent meetings with the Oasis Forum and the consortium of CSOs, student movements, and the church. So, insisting to refer to the Muniya Zulu case to say there was a pronouncement for wider consultations, therefore, Bill number 7 should not proceed at law, should be deemed, in our view, to be an abuse of legal process, because those pronouncements were after the fact that government had already deferred Bill 7 to allow for more consultations. I want to also indicate here that in our view, we find the pronouncement in that Muniya Zulu case, if not taken as just a guiding principle of constitutional amendment, that it is an attempt to, in fact, amend the Constitution by the court and not by Parliament by attempting to amend Article 79, which provides expressly how the Constitution of the Republic of Zambia should be amended. So, it is very important that the citizens do understand that in terms of this Constitution of the Republic, any law that is made by Parliament, or as a matter of fact, made by pronouncement of courts, which is inconsistent with the Constitution, to the extent of such inconsistency, is null and void. And that is the reason why, where we stand here today, we want the citizens to get the comfort that the National Assembly of Zambia is on firm ground to continue with the processes and procedures of Bill number 7, and that there will be no going back. We reject the notion being proposed and promulgated by the opposition and others that Bill number 7 should be ousted out of the National Assembly. There is no going backwards, because Bill number 7 is before the right forum. It is the National Assembly to decide the fate of Bill number 7 after hearing citizens who presently are making diverse submissions to the select committee, which will then come up with a report of recommendations to the whole House. So the question of Bill number 7 proceeding or not, in our view, has already now been settled, even by the courts of law. The nation also recall that in a recent matter of the Law Association of Zambia and 6 others, who include NGOCC and others, the Oasis Forum, through the Law Association of Zambia and 6 others, sought to challenge the legality of the technical committee by way of seeking a court conservatory order that the National Assembly should not proceed with hearing proceedings of Bill number 7, because a technical committee was set up to feed into the contents of Bill number 7. The court dismissed that interlocutory matter, where the Oasis Forum wanted an injunction to stop the National Assembly from performing their duty. It was dismissed, giving additional clarity that what the National Assembly is presently doing has no legal impediments. As if that was not enough, the opposition, through the latest case of Mundubire and Celestine Mukandila, in commencing contempt proceedings sought to stop those proceedings which are underway. And you all heard yesterday the same being dismissed. We want as government to take this opportunity to urge the opposition and the Oasis Forum to be considerate about what we are trying to achieve together as a nation through Bill number 7, that we do not are desirous to go to the general elections of 2026 with uncertainty surrounding an electoral petition that might arise in terms of Article 103, and also a renomination arising out of Article 52.6. We, as government, are desirous to facilitate a platform where through the proposed amendments to be brought into the Constitution through Bill number 7, there will be more women, youth, and differently abled persons represented in the National Assembly. Therefore, to turn the courts of law as a political battlefield for matters for which lawyers know beforehand that they are untenable is an abuse of process. The nation also even saw, when it came to this same case, which was dismissed yesterday, that even their lawyer had to vacate his stand to say, I'm no longer representing these people. Because I'm sure the lawyer now realized that, you know, this is not a matter for which you have to put your integrity as a lawyer at stake. Because as a lawyer, the training is that if you see that the case before you is a bad case, you have to ask your client to find a lawyer the next door. And I'm told that the lawyer in the next door they looked for was Makebi Zulu. I wish we were at the UPND Secretariat. I would have said something a bit more. But this is government. We are also concerned and taking note of what is happening in some of our institutions of government interest and citizens' interest in the governance of our country. Because government is a shared endeavor. It's not just for those of us who are privileged to be elected, but all those who hold various positions, such as the Law Association of Zambia. I'm aware that there is a matter now where Laz has been petitioned to explain why they are behaving in the manner they are behaving with Oasis Forum without proper guiding Oasis Forum on legal matters relating to what some members of Oasis Forum are standing for. And we would like to urge the Law Association of Zambia to perform their work diligently and professionally, because even after the elections of 2026, we want them to be in good standing with the citizens as a fountain of guidance on legal matters. We think that this far, they have gone beyond their usual advisory role now to begin to wear a jacket that sometimes may be perceived as being political and pandering to political whims and caprices. Bill number 7 seeks to iron out the creases of the law or lacunae that all of us as citizens have agreed need to be ironed out to avoid ambiguity of interpretation, so that we can have a predictable and stable law ahead of this very important election. It is important that we needed to say these things, dear colleagues and citizens, because we think that now the opposition are using Bill number 7 and their alliance with the Oasis Forum on Bill number 7 to launder themselves, so that citizens may forget where we are coming from and use that environment to dilute the attention of the nation away from important issues of bread and butter, of where the economy now is, and always keep the citizens busy with Bill number 7. In our view, attempts to block Bill number 7 is untenable. We thank the courts of law that at every stage where the opposition and Oasis Forum have sought to use the courts of law to oust and stop Bill number 7 out of Parliament and to be heard respectively, the courts have stood firm to ensure that the right things are done. We want to urge the opposition and the Oasis Forum that instead of spending too much time planning the next court action, let them go to Parliament and submit before the Select Committee, which is a composition of all members of Parliament in terms of political party represented in the House, so that their concern about non-wide consultation assertion can be addressed. We think that way we can move together as a nation. And like we said yesterday, it is government's hope that by the time Bill number 7 will be brought on the floor of the House for debate and voting, all the plaguing issues, all the perceived controversial issues will have been dealt with, so that we move on a platform of national consensus, because we have issues to attend to. So let me bring to the nation a reminder of one of the issues we must have been talking about and what it means now. That for the very first time in our country's history, the Zambian economy in 2025 has recorded 5.2 billion United States dollars foreign reserves. This, in our view, is a remarkable progress under President Hakainde Hichilema and his administration. The nation may recall that in 2011, when the Patriotic Front, which is the immediate past administration, took over the leadership of this country, they inherited a vibrant and buoyant economy, and also inherited not less than 3 billion United States dollars worth of foreign reserves, with at least 3 months import cover. In 2021, President HH and his New Dawn administration inherited a de facto junk economy one which would not meet its international balance of payment obligations and inherited less than $2 billion worth of foreign reserves with less than or about 2 months import cover. They recently pronounced $5.2 billion represents at least 5 months import cover. And what is the meaning of 5.2, or the meaning of foreign reserve or import cover? The meaning is that in the case of unlikely and unplanned circumstances that would lead us as a country and an economy not to produce anything for export, and we are not exporting to generate forex, which is the currency we use to buy goods and services from outside the country, such as fuel. The country today, without receiving $1 from outside through trade, is able to be a going concern without interruption for 5 months, because our economy now has, in terms of monetary and asset portfolio, a reserve worth $5.2 billion United States dollars. So if something unplanned happened today, we are not exporting copper, we are not exporting milling, we are not exporting flowers, we are not exporting coffee, we are not exporting avocados, we are exporting zero, we are receiving $0. We can still be a going concern for 5 months, importing our fuel without interruption. That's the meaning. And that is why we think as a nation, these are the things that we must spend time to acknowledge. And for us as media, these are the things we must spend time sensitizing and educating the citizens and covering those who are talking about this, not failed attempts of hosting and stopping Bill 7 from proceeding, when in fact at law, Bill number 7 is on terra firma. So dear colleagues, today we want to make it short, but I promised you yesterday that we'll be calling you at very short notice. Do you have any questions? Yes, please.
I'm Barnabas Azul, Minister for Interior Nation. So my first question is that the concern of the Oasis Forum, which includes the Law Association of Zambia, the Church Matter Bodies, has been not with the content of the bill.
Speak louder.
So the concerns of the Oasis Forum and other stakeholders has not been with the content of Bill number 7, but has been with the process that is needed in trying to amend the Constitution. And in the Munia Zulu case, with Celestine Ukandira, the court said that the process that was used in coming up with Bill 7 was not correct. And they said that you as government had abrogated several articles of the Constitution. Then thereafter you came up with a technical committee. Then last week you told us to say that those submissions by the technical committee, they are not going to be made to Parliament, like using a draft bill. Like they are not going to be taken to Parliament, because the process is that once they make the submission, the draft bill is taken to Parliament. Now I've got a bill which is before Parliament, which the court said that this bill did not follow the correct process. So do you think that proceeding with Bill 7 is it not contempt of court, or is it not against what the court pronounced itself on? And my second question is, why is it that as government you are in a rush to have this bill passed before the general election. Is it a matter of life and death for you as government? Thank you.
Thank you very much. Maybe I can quickly answer that before I get my mind into a deluge of other concerns. Firstly, two issues here, and please get me very clear, because if you don't, you as media, you will mislead people when it's not me misleading you. Number one, the question to do with process. We have explained ourselves, even yesterday, for those of you dear colleagues who were there at the Media Center Parliament. We have said the Constitution, this Constitution, is the fundamental law of the land. And therefore, this Constitution has provided legal mechanisms of amending it. This Constitution cannot be amended by the wishes of government or any other grouping. That is, in terms of means. It has prescribed how it is to be amended. So, Article 76 of this Constitution gives exclusive jurisdiction in what is called exclusive cognizance that it is the National Assembly or Parliament which has the prerogative to amend the Constitution, not any other. Now, Parliament is given that mandate to amend the Constitution through Article 76. Now, the question is, how should that be done? The answer is rooted in Article 79 of this Constitution, which provides that the National Assembly shall amend this Constitution via a 2/3 majority, that a bill brought to amend this Constitution at second reading should be supported by not less than 2/3 majority of members of Parliament. That is a process. 2/3 majority. The Article 79 goes ahead in terms of Article 79(6) to prescribe that when it is amendment of Part 3, Bill of Rights, you need wider consultation by way of performing a national referendum where only 50% of those who are eligible to vote should say yes to that national question. So Article 79 provides for two processes. One, where Parliament is mandated directly to amend all other provisions that stand outside the Bill of Rights, which we referred to the other time here as being not entrenched and not enshrined. Those articles that are in the Bill of Rights relating to human rights are said to be enshrined and entrenched, meaning they cannot be amended by Parliament there. Even if you have a 2/3 majority plus, you can't amend. But all other provisions, they can be amended. And that is why, even in terms of this Constitution itself, any other provision in this Constitution that is at variance with the provisions in the Bill of Rights, such a provision would not see the light of day. That is how this Constitution is. And that's how it works. So the process which they are talking about, I must now tell you that I think it emanates from previous constitutional amendment processes which required that a constitutional review commission will be set, then sent out to go the countryside to collect views from the citizens, and then they will do their report and present to cabinet what then is used to call a white paper. I mean, they would present to cabinet for consideration of that report. When cabinet sits, cabinet will generate recommendations representing the position of the executive, and they will call that report of cabinet as the white paper. It is that white paper that they would take now to Parliament, for Parliament to consider the views of cabinet or the executive. It is that process which was amenable to abuse, because then these views from the review commission would not be taken direct to Parliament, they would be taken to cabinet, and cabinet had the opportunity to begin to doctor that report. That is what that process meant and was questionable. Over Bill number 7, cabinet received the report of the technical committee and the attendant lay draft bill. And what cabinet did was to analyze the report and made considerations and concessions which shall be presented on Friday to the select committee in agreement with the technical committee report, because it is a product of people from across the nation. Yet, the technical committee has also been given franchise to go and present to the select committee at Parliament the whole report and the draft lay bill. That's what I said yesterday even. So the notion to say the technical committee draft, the lay draft bill should have been presented to overtake bill number 7 is untenable on two fronts. Number one, a technical committee has no legal competency to formulate a draft bill in terms of our laws. Only the executive cabinet can formulate a bill to present to the National Assembly. 1. 2. Only Parliament, through a motion moved by a member of Parliament, whether as a private member, can cause amendment through a bill of the Constitution. The judiciary and any other cannot take a bill, such as a technical committee. There is no legal provision that a technical committee can take a bill, notwithstanding the recommendation it contains. There is no avenue. It's just like at this press briefing, he said, only journalists from recognized media houses should attend. So you can't have anyone who feels they have an issue to iron out with government. Say, no, even me, I'm going to enter. So that technical committee, lay draft bill has no avenue of entry into Parliament to replace Bill 7, other than to be taken to the select committee, so that what it contains, the issues that will be in tandem with the objects of Bill number 7, may be taken in. It will still remain Bill number 7, but the contents might substantially change, but within the precincts of the objects of Bill number 7. Number 2, the law, Standing Order 122 of the Standing Orders of the National Assembly, which is the law that guides conduct of business of the whole House. is instructive that when a bill has been introduced to the House and it is withdrawn and or if deferred but not brought back to the House within that session but 6 months from date of deferment, it will be deemed to have been withdrawn, with the effect that a bill carrying similar objects, what are the objects? To amend the Constitution of Zambia, cannot be introduced in the House until after that particular session for which a previous but similar bill has expired. That's the law. So, even if the technical committee bill was drafted by the executive, it cannot be taken to Parliament. The executive can't draft another bill to take to Parliament because Standing Order 22 of the Standing Orders of Parliament does not allow introduction of a bill seeking to do the same thing as a bill which is already on the floor of the House. Daily Nation. Number 2 question you asked. Why is government in a hurry to push for amendments? If you go back to election campaigns, President HH and the UPND are on record having made various electoral commitments to the people of Zambia, even as far back as 2011, 2006, 2011, 2016, that once voted, government of UPND would seek to amend the Constitution. So when you say we're in a hurry, what do you mean? What do you mean? Secondly, on 30th of October 2023, a motion to amend the Constitution was taken on the floor of the House by a member of Parliament for Petauke, who was sent by all members of Parliament in agreement that let's use an independent so that this process does not look UPND or PF. So do you think that anyone saying we are in a hurry means well? Or they have a valid argument? They don't have. And in September 2023, in addressing Parliament, President HH brought to the attention of the nation various lacunae, one of them Article 52.6 and Article 103, and the need and requirement thereof, to amend those. Does that point to a government that is in a hurry? In 2023, and it is now more than 2 years, talking about the same thing, is that being in a hurry? Thirdly, if you look at the items that have been picked from Bill number 10 of 2019, that have found expression in Bill number 7, those are issues we did not oppose in Bill 10. But there were very few. The majority of the 72 issues they brought, we opposed. And yesterday I spent time to share with the media and the nation. At least 12 critical ones. It was just 12, there are many. We still have another session, which we opposed. And because the government then refused to amend those, we ended up rejecting the whole bill, because you can't accept some and rejecting others without voting to first open the Constitution. Because our fear was, if we open the Constitution, even on things we agreed, yes, but those we had not agreed, because we'll have already opened the Constitution, they will put them using the arrogance of numbers. So this debate has been raging for a very long time now. And it is just that government was of the view that it was important to take decisive action, particularly relating to those two issues in this constitution that stand potentially hazardous to a stable electioneering. And also the call for women, more women participation. How many Women's Day? Let's take even from 2001, for instance. For 25 years, you go every year when there is a commemoration of International Women's Day. There is no day when the women movement did not make a call to government to take affirmative action so that more women can be included in decision making, particularly in political decision making. And this is the first president who is saying, yes, we know it will cause debate, but this is what women, the youth, and differently abled have been calling for a long time. We shall do it. How can you accuse such a noble cause to say government is in a hurry? If that is what you are saying, to say we're in a hurry, yes, we are in a hurry to do what is right for the women, for the youth, and differently abled, because previous governments have been prevaricating around these important issues, leaving the majority of our citizens outside the realm and remit of decision making, particularly political, because that is where the power is wielded and exercised to make consequential decisions that affect citizens' lives. Thank you. I had seen a question there. Yes.
Honorable Minister, you've alluded to two articles there in the Constitution which relates to the elections. I believe those articles have been in existence for some time, different governments. Article 52 as well as 10.
No, just to guide you so that you ask a question straight.
Yes.
They have not been in existence with different governments. They were introduced in 2016 by PF.
Okay. Are you trying to use those two particular articles to stay in power longer or hold the nation to ransom by not holding elections? Yesterday, the Minister of Home Affairs and Indigenous Affairs was quoted to say we can use Article 52 to stay in power. Are you trying to use these two articles to remain in power forever or hold the country not to hold elections? Thank you.
Thank you very much. And quickly, maybe I can answer that one. And also the other issue you had raised, to say the Munia Zulu case pointed out to various articles that Bill 7 violated. We have this bill here. Maybe we'll give you a copy. There is not a single article that the court mentioned that Bill 7 had violated. Zero. It was just a pronouncement that in terms of practice and precedence, when it comes to constitutional amendment, it was necessary to consult widely. Now, the question you have asked to say, are we not trying to hold the nation to ransom? No. Honorable Mweetwa, and what he said, I will not even say he was misquoted. No. Honorable Mweetwa was just placing emphasis on the ramifications of not amending that particular provision of the law. Because a law should be predictable, a good law should be predictable. And when you are making a law, you don't make a law looking at yourselves being in power or office, because you will not be there forever. Hence, him, by way of emphasizing the predicaments that can arise, said we could end up remaining in office. Because yes, if you have a bad president or government, you have an electoral petition. And in terms of Article 103, the Constitution says the court shall hear. So the court can hear and not pass judgment. Where does that leave you as citizens? They can pass judgment 3-4 years later. Where does that leave you as citizens? In terms of Article 52(6), if a candidate withdraws a few days before the general elections, what happens? We are seeking to provide clarity that if, as a candidate, you withdraw, there should be mechanisms where that election should still continue so that we don't get ourselves into a constitutional crisis. Because remember, our date of voting is cast in stone. It is the Thursday of the second week of August of that election year. So that is very straightforward. So I hear you, and your question, you could be representing people whose understanding is influenced by these propagandists who are going around misleading people.
There has been a lot of pronouncements from people here about the two articles. To say we can stay in power forever because of these two articles.
This is...
So that's what I'm saying. Are you trying to threaten the nation through these articles? Why so much emphasis on these two articles?
There is nothing like threatening. There is nothing like threatening. We actually worried ourselves because we are the victims of this same article in 2016. Our petition was not heard. So we do not want another political party to undergo the malaise we went through. Just imagine you go to the courts of law and you are very expectant that the courts will pronounce itself like we were in 2016. And the court just said, no, it's time up. The one who is said to have won has won. No hearing, no judgment. Are you suggesting that as reasonable leaders we should leave this simply because now we have what people may perceive as comfort of office? No. We are in the business of providing leadership to country. So if PF introduced this absurdity in the Constitution, it is our job to get it out. Because we know a good law should not be good for us or them. It should be the whole country. So even to formulate such kind of an understanding is a fraud in itself. Because no one wants to hold country ransom. We are saying let's do what is right. It's just that again we are not placing premium on it. Maybe the question you should have asked me is, why are you insisting on amending these two? And the answer would have been given like we have given it before. An election is critical for the preservation of national unity and peace. Because citizens govern themselves through an election. Therefore, the law relating to the conduct of such an election should be predictable and clear, so that the result that comes out of such an election is acceptable by all citizens. That way, you maintain the peace of the nation. Peace of the nation and the stability of country is crucial because it lays the foundation for national development. Therefore, as a party who were elected on a platform of peace and development, we are just saying, let us iron out this particular law. And remember also, we don't take citizens for granted. We don't take citizens for granted. What if the citizens wanted to change government in 2026, which I know is not the case? But what if that were to happen and you have a rogue leadership that says, let's leave this because it is to our advantage? How are we going to explain to ourselves that we were in government, we had the opportunity to do the right things? We listened to propagandists and they carried the day. No, there's no going back on this one. And President Hichilema and this administration mean well on this one. He means well. We are not looking at a law that favors us or them. No, it should be a good law. Remember, let's not behave like those MPs in 2026 who didn't have grade 12 certificates, but all because of politics, started voting for a constitution which required that you should have a grade 12 certificate, and only to realize after the law was passed, no, I want to go and say, do you have a certificate? No, you don't qualify. They started going for night school. Is that what you want us to go through? No. So it's a mandate, dear colleague, but I hear you, because there are people with such views, but those views are democratic, because in a democracy, we should carry the views of the majority while respecting the views of the minority. Thank you.
Thank you very much, Honourable Minister. I think, colleagues, we have come to the end of our press briefing, and wish to sincerely thank you for having responded at very, very short notice. Thank you very much, colleagues.
So we'll be here again maybe tomorrow after.